Welcome everybody, thank you for coming to my panel, or not panel, my presentation on AI law and ethics. I will give you a quick introduction of who I am, why I'm up here, and why I'm speaking about this out of all the very intelligent, very informed people in this room. And I'm a little bit sick today, so please pardon my meat suit while I share what I have gathered with you. So I own an ethical art AI. Many of you know me as the creator of Mythulu. The year that I started Mythulu, I spent more than half of all the money I earned that year on art, hiring artists. And we tried, at first I paid hourly, but the first pieces were terrible, they were unusable. So to free artists from time pressures, I switched to paying by piece. Even after vetting quality portfolios, commissioned pieces had a 50% failure rate. In order to pay even a decent rate, we could not afford a 50% failure rate. I worked with over 30 artists from all over the world, looking for anyone who could produce reliable work. We were not married to any particular style. We tried tattoo line, art, watercolor, acrylic, digital. We looked into licensing pre-made pieces, but found outrageous amounts of plagiarism. It was very, very difficult to track down who the original artist was. And when I finally encountered plagiarism, even in commissioned pieces where I was demanding layered files and iterative work, and I realized they were just tracing someone else's work and ignoring the revisions I was requesting, that's when I threw my hands up. Mythulu almost didn't happen. And it would not have happened if it hadn't been for my brother. Came to me and says, well, have you heard about this thing called Google Deep Dream? So what we did is we took an open source AI, we did what's called forking it, and we made adjustments to the code so that it would fit our needs. That art AI saved us 95% on our art licensing. And in the end, we used stock art images and then we fed them all through an AI to repaint them like oil paintings and to repaint them in a common style. That is the art you see on the new cards. We've always been open about that whenever asked. We weren't super forward about it because we knew that AI would be controversial and we couldn't take the heat as a young business, but that is where I first got into AI, and I'm very passionate about this technology. I think it's a beautiful thing. I think it's a very enabling thing for a lot of entrepreneurs and authors and artists as well. And I'm looking forward to covering the ethics of AI with you today. So you can see our art results here. The original image is on the right. The AI result that we get out is not usable on its own. It requires human merging in the middle, but the combination of the AI and the human input together creates this beautiful aesthetic that we've become known for. The ethics of AI extend far beyond any individual industry. In the last 8 months, 2 new antibiotics have been discovered. In the entire history of knowing about antibiotics, we have only had a total of 9 in 3 families of antibiotics. This is nothing short of a miracle because these are 2 new antibiotics that form new families. So we now have 5 families of antibiotics. AI has drastically improved diagnostics in the medical field, from everything from liver disease to cancer. There's a beautiful AI project that is currently watched off in the Amazon. It can detect illegal logging within 60 seconds, and it notifies local tribe rangers and authorities to go and intervene. It is one of the most effective and one of the first effective programs that can protect the forest today. AI is also currently our best defense against the #1 cause of death in people in the USA, which is suicide. It is the 2nd leading cause worldwide. And AI is our best tool for identifying and intervening early. So I think it's really important to look at AI from the big picture of these other impacts that it has. I also want to clarify, I am not a lawyer. I am up here as a business owner. It is a responsibility of every business owner to understand the law in their field. And so I've been staying up to date on AI and will be covering cases that I have that have proven to be relevant over the last 18 months. So what you need to know is that most AIs do require training on vast sets of high data. Many of you are probably aware of these data sets. Most of our AIs were trained on a data set called LAN-5B. This stands for 5 billion. These are 5 billion images that were scraped from the internet. Large language learning models like ChatGPT were trained on a data set called Common Crawl in Books 3. These data sets contained 191,000 books that were pirated without permission. And Common Crawl contained billions of publicly accessible websites. So even though I am an advocate for AI, and I will walk you through the logic there, I am very upfront about that the origin and the way that this data was first acquired, this is where it came from. It was stored on a pirated website. So one of the things that I think has created a lot of contention in the discussion around AI is that there's an expectation of compensation. And this actually comes from the film industry. In the mid-1900s, there was a rise in litigation where people stepped forward and were trying to defend their copyrights. And the film industry took a big hit. A lot of artists were seeing their work appear in films and they wanted credit or compensation for it. And so they were taking films to court and holding up the release of a film. Because if a film gets taken to court, you can't launch it yet. And to prevent that very expensive slowdown, producers began to exhaustively license absolutely every piece of IP that appeared anywhere in their films. This has created the expectation of compensation, but that is actually not the law. So one of the myths that I hear is that if you hire a cover art designer to create a collage piece like the one you see, you're supposed to go and make sure that your artist is exhaustively licensing every image. The myth is that you can be sued if they use like a piece of sky or something, and any recognizable portion comes out that wasn't licensed. That is actually not true. There is a long-standing history in the United States and all across the world of something called fair use. And the basic gist of this is we all stand on the shoulders of giants, right? And it's important for us to be able to use the work that other people have done as a stepping stool to innovation and growth so that we are not forced to each independently reinvent the wheel in some sort of fresh way in order to do any work at all. So fair use has been fiercely protected for hundreds of years in this country. And there are 4 components that make a difference with whether or not something is considered fair use. Fair use, so the first is the purpose and character of the use. Is it educational or is it commercial? The second factor is what is the nature of the copyrighted work? Third factor is how much was used. Was it the heart of the work? And was the use of it transformative? And I'll show you some examples of what that means. The fourth factor is what is the effect of the use on the potential market or the value of the work? Does the use that it was used for change the value of the original work in some way? So none of these are cut and dried. They are all considered by judges when a fair use case comes to court. If you can pass each of these fair use sniff tests, you are permitted to use recognizable portions of other people's work without permission and without compensation. That's the law. So we're going to play a game of fair use for a minute. Now that you understand what the factors are for fair use, I'm going to show you guys some very important court cases from the last 100 or so years. And I'm curious to see what you guys think here. So we've got Mannion versus Coors. In this case, photographer Danny Mannion shot this distinctive portrait of NBA player Kevin Garnett. Without seeking permission, Coors Brewing recreated similar images for use in an advertising campaign. How many of you think this is fair use? Okay, we got about a quarter of the room. How many of you think this is infringement?
Was
Okay.
the person,
Confident third. It's an NBA player.
what was the person's picture? Was it like another picture of them that you?
Okay, so the question is, what is the second picture? So the second picture is a recreation.
With a different person?
It was a different person. It was a different model, a different photo shoot, but it was intentionally shot to look like one that had been taken before by somebody else. So the result here, this was deemed to be infringement. And the details are very important. So these were the factors that the judges cited when they made this decision. The presence of a particular watch was not sufficient, but the deliberate recreation of stacked jewelry and the arrangement of the hands were too similar to be accidental. This was considered the heart of the work that had been taken without permission, and that's why this was deemed infringement. The fact that it was being used for advertisements and commercial work was also a factor. All right, so here's the next one. We've got Blanche versus Coons in 2006. Fashion photographer Andrea Blanche produced this Gucci advertisement. Artist Jeff Koons cropped and pasted the magazine clipping into a montage painting titled Niagara, which aimed to comment on consumer culture and the bombardment of media imagery. Blanche sued because Koons had used a significant, recognizable portion of her work. Raise your hand if you think this is fair use. If you got half the room. Raise your hand if you think this is infringement. About a third. This was deemed fair use. And I think this is really important because this was a very important case that really brought home, there is a recognizable portion of somebody else's work that has been reused in a collage. This was deemed fair use. Cairo versus Prince. Richard Prince, the artist, was an artist who altered images by Patrick Cairo, a photographer. Cairo produced a photo book called Yes Rasta. Prince was known for his commentary on pop culture, the commodification of images, and the nature of art and authorship in the digital age. He took these images, painted over them, altered their context, and combined them with other elements. For the people who are listening in to this on audiobook, it is a mostly recognizable image that has very badly done collage pieces put over a tiny fraction of the art. Raise your hand if you think this is fair use. Okay, about a tenth of the room. Raise your hand if you think this is infringement. More than this, about 90%. This was a very controversial case. The first court sided with the photographer. Prince appealed. The U.S. Court of Appeals determined that 25 of the images met the criteria for fair use on the grounds of transformative use. This illustrates the extent to which transformative commentary and art with purpose protects fair use of prior art by other creators. So even though the majority of the work, and I would even say that the heart of the work, was borrowed here, because there was an intended message behind the reuse of somebody else's work, this was defended in the U.S. Court of Appeals. Roger versus Coons. This is a case from 1992. Roger was a photographer and Coons was a sculptor. Coons claimed defense of parody. So this sculpture, The String of Puppies, was recreated from an image. The sculptor left instructions for his assistants to recreate the sculpture as closely as possible to the photograph. These are two completely different mediums. And slight adjustments were made. They put little clown noses on the puppies and they put flowers in the hair of one of the women on the photo. How many of you think this is fair use? Raise your hand. About half the room. How many of you think this is infringement? A couple of hands. This is infringement. The court said the similarity was so close that the average layperson would recognize the copying, which is considered a standard for fair use or not. Unnecessary similarity without sufficient commentary. So this was not fair use. The sculptor was trying to defend his parody, but the court decided that the sculptor was intentionally trying to profit from the way that the photo had been arranged, rather than trying to add any additive value to the art. So that's why this is infringement. Goldsmith versus Warhol. This is one you may have seen in the news when AI first hit the news. A lot of people were citing this one as being like, ooh, this is going to be a decisive case for AI. So this one was just finished last year. This is one of the first fair use cases to go all the way to the Supreme Court. So what happened here, Lynn Goldsmith was a photographer who shot this portrait of the musician Prince. Goldsmith licensed the photograph to Vanity Fair to be used as an artist reference for an illustration and published once with credit, which was done in 1984. Warhol, who was the hired artist, created additional works. When Prince died in 2016, Vanity Fair published a special edition with Warhol's full Prince series. They did not credit Goldsmith in the second publication. Goldsmith claimed that Warhol's use of her photograph to create additional works violated her copyright. This case went all the way to the Supreme Court. Raise your hand if you think this is fair use. This is a very stylized image, but the arrangement is the same. Raise your hand if you think this is infringement. Okay. The majority are siding with fair use, but there's a good number of people who think it's infringement. This was an interesting case because the judges were very reticent to say one way or the other. They decided that the contract won because there was a pre-existing agreement between these parties and that agreement had not been honored. Vanity Fair had exceeded the allowed use and did not credit any additional publication as was contractually agreed. They did leave some fair use commentary. They said, fair use must serve a distinguishably different artistic purpose. So repackaging of an arranged presentation of something like the musician Prince was not deemed sufficient transformative use to be fair. The high commerciality of the use was also a factor there that the judges would have considered if this case had been decided on fair use alone. This one's a very interesting one. So yesterday I was in a panel, and one of the panelists was insisting that any commercial use negated fair use, and this is a court case that answers that question. Google versus Oracle. So in the development of Android phones, Google copied and pasted 12,000 lines of code that defined 37 Java APIs. Google wrote its own implementing code for Android. When Oracle purchased Java in 2010, they sued Google for not licensing Java's code. After a decade of legal battles, 2 jury trials, and multiple appeals, who do you think won? Is this fair use? Raise your hand if you think it is. We have 4 or 5 hands. Raise your hand if you think this is infringement. About the same number of hands, but nobody's really sure. They're very hesitant. This was fair use. The Supreme Court ruled that Google's copying of Oracle's Java API for use in the Android operating system was fair use. The court's opinion emphasized that Google's use of Java's API was transformative and enabled the rise of a new and innovative platform which significantly contributed to the progress of computer science in a way that is distinct and different from Java's original purpose. So commercial use is not black and white. This was a very commercial use of code that was directly copied. So this is also a very important case to understand. One of the other things you need to understand when it comes to fair use is that style cannot be copyrighted. Style is not protected because doing so limits the ways that other people can create new works. This is so firmly entrenched that I could not find a single case where this was even argued, that somebody had borrowed somebody else's style. It's always argued that they're trying to copy a specific work in a way that's unfair. So, a couple of years ago, when researchers started digging into the AIs that have exploded across the news and become so important, they had very good reasons to believe that the datasets they were using were fair use. And they had 3 layers. It's a research-based use. They are aiming to understand and use reasonable portions of the work that had been borrowed, and the use is transformative, because it's significantly furthering both science and the arts. One of the things that's also important to understand, I think it's interesting, the discussion of AI has changed many of people's opinions about fair use. And clearance culture is not the legal standard. It may in the future become a legal standard because The law does flex and it changes over time as our understanding of ethics can change. However, you cannot be accused of a crime when the law was formed after your choices were made, and this is a very well-known legal standard known as non crimen sine lege. So it means no crime without law, or no crime before the law. So let's talk about what the AIs are actually doing. Is it collage or is it comprehension? This is how generative AI works when it comes to art. The AIs are fed massive data sets, and the AI is trying to understand what each individual image is. So it's fed pairs of images and words together, and it is trying to form a 3D comprehensive understanding of each concept in many forms. It is actually both. It can understand with a great deal of information. It can develop a vast and flexible understanding of what something is. But when you have a very narrow data set, kind of like with people, we develop biases about what we think something is. And we hold on to snippets and very firm images of that understanding of the concept. And AI will do the same thing. So this is known as an entrenchment bias, and it can cause a narrow data glitch. So while you are using an AI for generative art or generative words, if your initial prompt happens to pull from a part of the data set that the AI does not have a vast understanding of. So if you say, I want an understanding of this particular person, and there's only like one picture of that person that appears on the internet repeatedly, then that's what the AI thinks of that entire concept. It's a very entrenched concept, and the AI can spit out and recreate the images that went into its data set. So you are responsible as you are using these generative images, just like if you were using Photoshop and you recreated something that would be considered infringement of Pixar or Disney. You're responsible for how you used the technology. The technology is not responsible for your infringement. And it's the same way here. If you are using an AI for generative purposes, you are responsible to do your due diligence to make sure that your outputs are not infringement on any existing art. So that's an extra step you have to take that you didn't used to have to take when it comes to the creation of art. Now, how do word models work? Because we're all authors here, right? And I think I'm really excited to explain this one to you. So LLMs are a brilliant system. What happens is somebody decided to take words and give them a bunch of numbers. And it's kind of like how Sydney, Australia has numbers attached. It has latitude and longitude, right? And London has a latitude and longitude. And using those two numbers, you can calculate the distance between the places, even if you have no other information. That's how LLMs work. This is a system called word vectors. So each word is given 120 dimensions instead of 2. And you can calculate using sophisticated calculations. Every time you ask ChatGPT for a query, it does almost 100,000 calculations trying to understand what you mean. And using this word vector that helps it understand the relationship between words on a mathematical level, it can calculate what you need. So what happens when the model consumes new data is it nudges the numbers in these word vectors. It nudges the associations between words. So if you have an input of data that tightly associates two words that were previously not associated at all, you will see drift in the underlying algorithm where those two words come closer together and these particular numbers within their 120 dimensions. So that is how an LLM works. This technology is known as word vectors. And I think this is really important to understand because a lot of authors are very concerned that their work has just been sucked in and that it's being collaged out the same way that art AIs are capable of collaging work out. And they're two different types of technology, really. One of the other things that is relevant here is that these LLMs actually rely pretty heavily on human input. If you train an LLM repeatedly on AI-generated data, if you do this 5 times, the entire algorithm collapses because it turns into noise. It's just scattershot and it can no longer run the calculations it needs. these LLMs are vulnerable. This is new technology. There is new security protocols that are being developed every day, new patches that are being issued. This I thought was a funny vulnerability that was patched pretty quickly. If you asked ChatGPT to repeat the same word forever, it would obey, but then it would want to express its underlying algorithm, and so it would begin to reveal data that was in the data set. And in this instance, it did reveal very sensitive data like user email addresses and stuff. And I don't know how that worked. But so there, and that's why I say like it's a mixture. There is some collage, there is some retention of the data underneath in these word vectors. But it's something that the companies who are building these AIs are working on to hide and protect that data better over time. So, but you should be aware, if you are using this technology, it's not perfect. So let's talk about some copyright precedents in each other. Yeah, you're doing okay. There's a very important legal precedent. This comes from 180 years ago. The case Burrow-Giles versus Sardi was the very first case to protect photography as copyright. Photos have been around for 60 years before this was defended in court. Somebody shot a photograph of Oscar Wilde, and that's what you see on the left here. A publishing company, a newsprint company, decided to copy that photograph, print it out, and sell little photos for people to take home. The photographer took the publishing company to court, and the court sided with the photographer. The court's reasons for doing this are super relevant today. The judge said mechanical capture was protected because conscious choices created something new. Mechanical capture was protected because conscious choices created something new. Now, anyone who has played around in Midjourney or ChatGPT knows that prompt crafting takes a lot of thought. It takes a lot of input. These are conscious choices and intentional choices. On the photography side, this standard is very fiercely protected, and over the last 180 years, there's been a lot of cases to eke out the nuances of how to apply this standard. So, my favorite example: if I go to a party and I have a friend who's very drunk, and I let him use my camera. Okay, my camera, he's blackout drunk. He accidentally presses the shutter, and he's so drunk he doesn't remember taking this picture, but somebody else is video recording the moment, so they have evidence that he was the one who pressed the shutter. So it's an accidental photo, it's not his camera. Guess who owns that copyright for that image, if that image happens to turn out to be something valuable? He does. He pressed the shutter. He was the human being who accidentally pressed the shutter, so he owns full copyright of that image. That is the standard at which, the level at which human protection is created. That's how low it goes when it comes to photography. So if that's the standard for photography, I just want to put that question out there. Why is intentional prompt generation within a generative AI capacity not met at the same standard? So I understand that this is difficult and murky waters, that change is very startling to all of us, but I think the precedents here are very clear. So a case that you might hear your friends bring up, there's a monkey case. This photographer's name is David Slater, you see one right. He set up a camera, and this macaw monkey, Naruto, so David Slater set up the camera, picked the exposure, put it in a good place, and the monkey pressed the shutter. So who owns the copyright? David Slater now filed a copyright trying to give Naruto the copyright, and this case went to the Supreme Court in both the UK and the United States. And the outcomes were very interesting because the different countries had slightly different nuances. This is an animal rights case, okay? This is not a copyright case. The UK, or in the United States, it was determined animals cannot hold copyright. That's fair. The UK decided the same thing, but they went one step further. And they said, in the absence of human input, the next most involved human deserves the copyright. Which seems like a very fair and reasonable standard. That is not established here in the United States, but it's a good common sense standard, I think. Thaler versus Perlmutter is another case that you may hear cited. So the image that's on the screen right now is when it won the Chicago Blue Ribbon at the State Fair. This is actually in the digital art category. So there were a lot of people who were upset that an AI piece won a Blue Ribbon, but it was in a relevant category. Thaler is the data scientist who is probably single-handedly most responsible for generative art in the first place. He is a quirky guy who believes in things like experimenting with traumatizing an AI because it forces it to draw creative conclusions between unrelated things. And he has a deep and passionate belief in the potential for AI to make sentient choices eventually. And so he's an advocate for robot rights. So he tried to file a copyright for this image called Entrance to Paradise. And he tried to name his AI, Dallas, as the owner of the copyright. So this is actually not a case on whether or not AI art can be copyrighted. This is a robot rights case. This one went to the Supreme Court, and the Supreme Court decided, no, sorry, robots cannot hold a copyright. Now, this same data scientist is really pushing the issue all over the world. Dallas is a multimodal, very clever AI that is also capable of generating patent ideas. So the AI made up some patent ideas and filed them in countries all over the world. It was denied in those countries, but he was actually granted patents. The AI was granted patents in South Korea and Australia. So the international standards here for robot rights, even on a fundamental level, are not universal, and countries are beginning to take different stances. There's even a robot named Sophie who has spoken in front of the AI. She is powered by ChatGPT, that's how she speaks. And that robot has been granted ceremonial citizenship in Saudi Arabia. So we're at a very interesting tipping point in human history, and these are some of the cases that I think are useful and fun to be aware of when you're talking with your friends and colleagues about these cases. Now let's talk about Zarya of the Dawn. Zarya of the Dawn was a comic book where right after Mythulu came out, this artist Kashtanova put together a comic book series and immediately filed for copyright. And she was pretty quickly granted copyright from the US Copyright Office. She went onto Twitter and started bragging that she'd been granted copyright of her AI art. And the Copyright Office naturally caught wind of this. In her original copyright application, she had not stated that this was generative art. And so the Copyright Office rescinded the copyright and asked her to resubmit some additional evidence that there was human input involved. So it was sort of an appealed copyright situation that went back and forth for a little while. When you file copyright, you are asked, is this a derivative work or is it a compilation of other people's work? And you are specifically supposed to indicate any pre-existing material or pre-existing work that your work is based on or incorporates. This is where you need to indicate when you file for any sort of copyright on AI-generated work that it is AI-generated. You need to specify very clearly what was AI-generated. And then in the next section, you have your opportunity to defend the human inputs. They want to know what material you added to the work, and they want a brief general statement of the material that has a human foundation, because that's what they're aiming to protect with the copyright. So this went back and forth for a little while. The Copyright Office finally granted copyright for Zarya of the Dawn, not for the images within the comic book, but for the arrangement of the images and the words that were in the comic. And when they granted that copyright, they also issued a statement saying that AI-assisted art can be copyrighted if a human selected or arranged it in a sufficiently creative way. So let's cover some of the major AI lawsuits that are going on right now. It's been spicy out there. I think it's really important. I know you've heard a lot of cases, so I'm going to get you up to date on outcomes and likely outcomes. And one of the things I want to make you aware of, FTC did a report in 2019 on how most class action lawsuits turn out. They discovered that class action lawsuits average 2 to 3.5 years to resolve. 87% of class action lawsuits result in zero payout. 87% result in zero payout. Of the 13% that settle, the awards average $32 a person. So those are glaring statistics, and I know there are a lot of cases out there right now that I'm going to cover, but I just want you to keep that in the back of your head, that even if these cases go all the way, even if the big companies, the authors and the artists, when they get against these big companies, the payout is not likely to be satisfying for the people involved. One of the cases that has been filed was Gibran versus Meta. This case includes a Pulitzer Prize-winning author named Michael Gibran. It includes comedian Sarah Silverman and co-authors of the Oppenheimer biography that was adapted to the hit film last year. This case was dismissed, and when it was dismissed, the judge said, "When I make a query of Lama, I'm not asking for a copy of Sarah Silverman's book. I'm not even asking for an excerpt." And he dismissed on the grounds that it's not spitting back recognizable work on a regular basis. And they were allowed to refile. They did refile, but the judge warned them that if they cannot prove that the outputs are sufficiently similar to the inputs, that it will be dismissed again. Anderson versus Stability, Anderson versus DeviantArt, Anderson versus Midjourney, these were all dismissed. That was in the district court in California. The Authors Guild versus OpenAI. This was filed in September of last year. And the Authors Guild issued a statement saying, "At the heart of this technology is systemic theft on a massive scale." I know that they put out a letter that was signed by over 12,000 authors. The Authors Guild is exclusively representing professional fiction writers, which makes this case a little bit different. There are 17 other authors on this lawsuit, including the Game of Thrones creator, George R.R. Martin, and authors Aline Hildebrand, Jonathan Franzen, and Jodi Pickle. So this case is pending, and it's not certain what the outcome of the case will be, but many of the other cases that have been brought before courts have been dismissed on the grounds that the outputs are not sufficiently similar to the inputs. There's a statement that was issued a while ago that I thought was relevant. This was by Justice David Souter, who was a retired Associate Justice of the U.S. Supreme Court. He said the goal of copyright is to promote science and the arts, and that's generally furthered by the creation of transformative works. So when we're looking at copyright, I think most of us look at it in terms of how can we protect ourselves. The FTC is a fan of competition, and these courts are a fan of innovation and growth. And so from a government perspective, although it may look heartless to allow fair use, they are incentivized to see their citizens grow collectively over time, whereas we are incentivized to grow personally over time. So similarly, like I want to be the hero versus how do we protect the hive situation, I think that's where some of the tension is appearing. The WGA strike went on for half a year last year, and there have been, I've seen conflicting rumors about that contract, so I actually went back and read it and looked at the report. So this agreement that was struck between the Writers Guild and producers in Hollywood, this agreement lasts through May 1st, 2026. So it's an agreement that's good for about 2.5 years. And in this agreement, it was decided that AI-generated written material is not considered literary material, source material, or assigned material. So what that means, as far as I understand, and again, I'm a lawyer, but I think what that means is that the producers were agreeing not to run straight to film using AI-generated material that had never been touched by a human. So they're trying to support and encourage the ongoing input of authors and creators. Other things that were decided on and negotiated, it was decided that writers can use AI during writing services if the company consents. Writers must disclose their use of AI. Writers cannot be forced to use AI. A company must disclose to a writer if any material they are given to rewrite includes AI material. That is all that was decided. There was also a really funny rumor that went around. I heard a rumor that Japan had taken a stance in favor of AI-generated material. They are a pretty tech-positive country for the most part. I dug into this one, looking for the original source, and it turns out this is a rumor. Japan has not taken an official stance. The rumor came from, what was it? It started on a small news website called Technomancer, and there was basically a minister of a subcommittee in Japan who had a meeting and was reporting on the meeting notes of what they discussed. And they discussed that, like, hey, yeah, we should talk about this AI thing and it might have an impact, and maybe we should talk about the good it can do and not just the bad. And somebody ran away with that and made some really headlines. But that is, Japan's official stance right now is that they do not have an official stance. Now, there is one incident where AI-generated work has been protected so far in the entire world. The Beijing Internet Court on November 27th of last year, awarded 500 yuan, which is about $70, to the AI artist who generated the images on screen here. They were used by a newspaper without permission or without compensation. The artist took the newspaper to court, sued, and the Beijing Internet Court awarded the original artist and forced the newspaper to pay damages. So this is an interesting precedent. This is a district court. I don't know how this will hold up in China's version of the Supreme Court if it goes that far. But this is the first and only case that I can find where AI-generated work has been protected, unaltered. Now this question of should AI work be copyrightable? I believe it should. I believe this very firmly, and one of the reasons for that is that if we do not copyright, if we do not allow AI outputs to be copyrighted, then it forces all of the artists who are working now to compete with AI-generated work. If you allow it to be copyrighted, then artists can incorporate the tools in the process, and it allows them to grow with the technology and make a better living that way. So that's my primary reason why I feel strongly about copyrighting the AI-generated art. I do believe that the court cases support between the mechanical capture from Starr and Giles and the fair use layers that have gone into the research that now supports this new technology. I think the case is strong in favor of AI. So if you are using generative AI, you need to, I would recommend try to have a transformative intent behind it. We're artists, and we have a reason for the work that we're making. So know what your purpose is, know what your thesis is behind your work, and try to let who you are and what you feel and what you're trying to comment on about this world really sing and come through in the material you request from these AIs. What you get back will not be perfect. Edit it. It's going to result in better outputs to begin with, and it then becomes more defensible on a copyright level. When you file for copyright, you must list yourself as a copyright owner. Do not list the AI as the copyright owner. Do not list Midjourney. List yourself as the copyright owner. You must also clearly state that the source materials were AI generated, but that the final piece is the result of human labor. State precisely which changes you made. And then lastly, in that same section, I would recommend that you cite mechanical capture and conscious choices. Cite Burrow, Giles versus Starr. I would love to see that phrase go to the Copyright Office over and over and over again until they're sick of it. Now I've studied creativity for 6 years. I've interviewed authors at every level. I've researched the neuroscience behind animation. I've read books by Nobel Prize winners. Innovation is my jam. Your books can never be removed from these algorithms. If you are among the authors, the selling authors whose work was fed in the first place, I'm sorry, it's never going to come back out. You will probably never be properly compensated for these machines digesting your work. But let's be honest with ourselves, we didn't invent computers, we didn't invent the internet. We're not solo heroes, not really. We're a hive. And I think a lot of us, it's easy in our culture to have a cowboy mentality and want to be the hero. But I hope in the absence of an extra $35 in your bank account, I hope you can appreciate that every word you slaved over is contributing to discoveries like antibiotics, gene therapies, cures for cancer, rainforest protection, and suicide prevention. That's all I have to say today. Thank you for coming. Are there any questions?
I have one.
Yes.
How do the AIs do suicide prevention?
So the question is, how do AIs do suicide prevention? This is a case that a lot of people feel very strongly about. Suicide is a big issue. It's touched a lot of our lives. Facebook was actually the one who pioneered a project in 2017. They realized that their social network was being used for a lot of cyberbullying. And they also realized that they had unprecedented access to people's personal expressions. Facebook did not reveal their underlying algorithms. I think that there was a lot of work where they were trying to understand statistically which expressions were useful and which were not. I know that they were looking at not just the comments of people who posted something like, oh, I wish I was dead, but the comments that people made in response to those posts. The comments like, where are you? Are you safe? Are you with somebody? Dramatically increase the likelihood that it was a real threat versus, people laughing along and cracking jokes on the thread was usually an indication that the threat was not as severe. It's been 7 years since that project was started, 7 or 8 years. And since then it's been handed on to a group of universities that are working together as a team. A whole coalition is working on a really beautiful project where they are leveraging all the data they can find in every way that they know how. I think they're using everything from, I know a lot of it is social media based. It's based on the expressions that you put out there on the internet. So I don't know the answer to that all the way, but I'm very much in support of that work. If you're interested in more, the notes to the that big project, I forget the name of it off the top of my head, but the links to that project are actually in my slide notes that will go up on the Superstars website. Okay. You're welcome. What other questions are there? Yes.
If you were to declare an AI-generated piece of work specifically to be public domain, how many things in what you've discussed would go away, and how many would still be these gnarly, weird, conflicting fights? It seems like there's a mix between the two.
This is a very emotional discussion, really. So it sounds like, so the question was, if you make something with generative AI and then you declare it to be open source, right, like Creative Commons, you aren't claiming copyright for yourself, you're saying it's part of the public domain and you want it to be usable by anyone, does that address some of these snarly legal issues? I don't know. I think that what you're really asking is, will people accept the art if it goes in the public domain? You don't know? It's still the question. So let me think about this. So if you have a work in the public domain, you can use it for commercial purposes, right? So that means the work is out there, I can use it for a commercial purpose. If you say that you made generative work, you put it out in the ether for anyone to use, but then you still use it for commercial purposes, I think that there's still like a sniff test there, like an emotional part where people are saying, yeah, but you're still using it for commercial work. So I think the objection isn't who owns it in that moment. I think the objection is, should it be used for commercial purposes? I think it still goes back to what's the origin of the work that people are debating. And I think that that is going to have to be answered and resolved before before some of the public domain issues can be addressed.
And it seems like the original sources of the generative process, that doesn't get addressed at all by that.
Yeah, the original sources of the generative process are not addressed by the public domain. What other questions do you guys have today? We have 10 minutes left, so I made space for you if you have even like personal questions about a project that are more specific. I'm happy to answer those as well.
Do you know when you have to put into it what is AI generated about your work? How specific do you have to be? Like if you use it to like generate beats for a scene versus to actually generate the text itself, and then how much you edit it, precisely how much, like it seems like that could be a really wide range of detail.
Yeah. So the question is how detailed the inputs have to be. Is that what you're saying?
Yeah, like when you're filing for copyright and you're trying to say what was AI generated, what was human edited.
Okay, so when you're filing for copyright on AI-generated work, how complex do your prompts have to be in order to claim copyright, right? And that's a good question. I think the current U.S. Copyright Office is a little gun-shy. They're definitely not fans of AI. But it's a difference between people who are executing the law versus what is the law itself. So the people who are currently running the U.S. Copyright Office are definitely resistant. My advice would be the more human input that you can demonstrate, the better. So we're going to be doing a presentation in the next hour on author workflows, where I will show you some of the inputs and outputs that you can have, and where AI influences the creative process. You know, in my opinion, based on the legal precedents and the cases that I have just stated, theoretically, if I fall asleep on my keyboard and I accidentally generate something and I turn out to like it, or if I live in the UK and my cat walks across the keyboard and hits send, right? Like in either of those situations, theoretically, I should be able to hold the copyright immediately to anything that was generated on, that I generated or was generated on my laptop, at least based on like photography standards. However, I think with the current attitudes at the U.S. Copyright Office, you know, they want to see that you care. They want to see that you care about your work, and I suspect you do care that anything that you're going to put out there with your name on it, you know, anything you want a human being to read on the other side, you should read yourself and vet a little bit. So, does that answer your question?
Yeah.
Okay. Cool. Yes.
So your current process is you're using stock art and then applying a filter on it. Have you put any thought toward cutting out the stock art and AI generating your base images?
Yes, I have. So the question is how I, based on the Mythulu AI, which currently licenses stock art, feeds it into our AI to be painted, have I considered a different process where I cut out, you said cut out stock art images and basically start with the AI generated?
Start with the AI generated.
Start with the AI generated image. Yes, I have. And it's something that, so Mythulu owns copyright on 562 pieces of cards right now. One of them, which is not currently available for sale, was AI generated to begin with. And if you can tell me which one, if you can figure out which one, it would be. Stock art images are incredibly biased on so many levels, and it actually makes me really upset. I have reached out to stock photographers who contribute to the databases that I pull from and begged for more diverse work that is representative of more races, more ethnicities, more lifestyles, wider age, different body types. And the sad fact is that people are really shy about being in front of a camera. And if people are not stereotypically pretty, a lot of them are willing to step up and be models. And being a model is kind of a luxury hobby to begin with. Like, to be able to go and waste your time putting on frivolous dresses, it's a white people hobby, let's be honest. But what that means, unfortunately, is that the database that I have to pull from is incredibly biased. I'm very self-conscious about the lack of diversity in our cards. I have run statistics on the diversity in our cards, and I am not satisfied with them right now. I would like to be able to produce art that is still beautiful and better represents the people on this planet. I can't do that with the current array of stock photography on the internet. I have spent 6 years scouring the best available art that's out there, and the art I want does not exist. And when I first saw Midjourney, even when the outputs were messy and imperfect and incomplete, I got so excited because for the first time ever, I could make beautiful images of Black men in beautiful fantasy robes. Nothing like that exists on stock art. I could create things that were gender inclusive. I could create even a lot of the diverse imagery that's on stock markets right now is so trite, and the high-end stock photography that's more like fantasy or sci-fi oriented, the finer art, it's all white models, all of it. So it's one of those things where, like, on the impact, on the good that great art can do, I see profound potential for the AI art to expand diversity and represent broader people, just help that art out there. And I'll say one last thing here with my time. If you're an artist, you are somebody who cares about putting beautiful things out in the world, right? And a lot of people are afraid that AI is going to take jobs away from artists. I don't see it that way, okay? I'm an entrepreneur. I am willing to pay money for good art. I can't hire artists to hand draw art because the failure rate is too high. It's unaffordable for me. It's unsustainable. But I would love to work with artists and hire people like the same amount of hours that people are willing to put in as an artist. Like, if you're willing to put in 40 hours making beautiful art, and then you can produce things consistently, more quickly, that I can actually use, then I can actually hire you. I can actually pay you. So I look at this innovation as an amazing bridge builder between the people who are willing to hire artists and the people who want to be artists. Because the art that a lot of these aspiring artists have been putting out has not been good enough to be able to hire them, if that makes sense. So I think there's a lot of potential. I would love to get away from doing a lot of the art directing on cards and be able to hand that off to somebody who cares about art as much as I do. And AI is one of the first things that makes that possible for the first time since I started this business. So I think that I would encourage you, if you are interested in this at all, to crack it open, give it a try, give it a chance, see where it fits into your workflow. I know that it's messy out there, and if any one of you are not game yet to join that sparring, to hop in the fight and speak up about AI, I totally understand. But if you are, I'll tell you what, a lot more people have been supportive this week of me being up here and painting a big target on myself and saying, hey, guess what, guys, these cards that you love, I've used AI. Over the last 6 years, I've used AI from the beginning with them, and a lot of people have been incredibly supportive, incredibly kind, incredibly grateful that somebody is standing up for the technology, and you may find a warmer audience than you expect. I think that a lot of the people who have been speaking up have been allowed speaking wheels, and a lot of people have been very quiet, sitting back to see what will happen. And in order to turn the tide of the conversation, it's time for people who care about this technology to stand up and say, I believe in what we're doing. So, thank you so much for your attention today.